झूठे केस में फंसाया गया है, पुलिस सबूत छुपा रही है या चालाकी कर रही है? So, there's actually a legal way to expose a dishonest investigating officer. And well, it all begins with understanding two sharp weapons in the Criminal Procedure Code, Section 91 and Section 311. Okay, let's start with Section 91 of the Criminal Procedure Code. This section, basically, lets you summon any document or thing to court, even if the police tried to suppress it. Think of it, honestly, as your flashlight in the dark corners of the investigation. Missing site maps, tampered general diary entries, CCTV footage that mysteriously vanished. You can actually file a written application under Section 91 asking the court to summon these directly. And here's where the strategy really comes in. Use it to bring in documents that contradict the investigating officer's case, especially if the charge sheet conveniently omits facts or, misrepresents evidence. It's not just about the document, it's about what it reveals. Suppression, manipulation, or, even selective presentation of facts by the investigating officer. Now, once you've got these documents, enter Section 311. Section 311 allows you to recall or summon any witness, including the investigating officer. Yes, even if he's already been examined. Why recall him? Simple. You confront him using the very documents he tried to hide. Cross-examine him on false seizure memos. Question the absence of mandatory procedure, like compliance under NDPS or CRPC sections 50, 55, 57, or fabrication of 161 statements. And here's the killer combo. Use Section 91 to expose the paper trail and Section 311 to corner the man behind it. Together, they allow you to demonstrate motive, bias, fabrication, and even collusion within the courtroom using lawful means. So next time you're defending a client or yourself, don't just argue, strategically dismantle. The CRPC has given you the tools, the rest is in the execution.